Abdul Kuo Bazun Capital Attack Pagano, but Mafu had his actually pinnacle. Anuki fi and Aishi Pikalu Kula Shikalu. Na at the Kun Fikalu. Anuki Ferragun Shikalu Wakalu Ferragushi. Anuki Wahid Bakalu Wakalu Wahid Man. Aikilu Angie, Kama Ferragun Shikalu Wakama Ferry. Aikilu Aquenu Kudu Kofin, Kama Tawukamaka Father Kalu and Anuki Kabahawa. Kalu Kalu Anuki Kalu Yakun Keki. Kalu Babu together. Again, all peers I am in the double all that we are all in all. I am a part of all and all is a part of me. I am one with all and all is one with me. I can succeed as a part of all as well as an individual. I can be all I wish in all as long as my wish is to stay in all. I am never alone. All is I am. All can I can. All does I can.
All right. I want to go from Adrian Packer's motion for new trial to Jonathan Mark's motion for new trial based on newly discovered evidence. Bear with me for 1 second.
All right. We got a handle while we're waiting.
All right.
You got a question? You can unmute right now.
My name is Rochelle too. So I heard you say something, the young lady named Rochelle. I'm the good Rochelle. So we're going to move forward in this case. And I see that all these numbers, the dates, that's what I'm worried about. The dates is everything was in the early 2000s. Like we've been dealing with this, well, not me. His family has been dealing with this for at least 20 years. Mm-hmm. And I, like I said again, I do appreciate you giving us the understanding on this case. But one thing I was wondering, did anyone do I think it's called a subpoena or something to get the whole, what is it called? Oh gosh, is it the whole case file? Like with the judge and what everybody wrote down?
You talk about in this case?
Yes, in this case, you could basically get like all the information from with the judge standpoint, from his thinking, instead of assuming what we think they're saying. Because it's a lady judge that's giving away all the secrets is on Messenger. So basically, what she's saying is you can get a certified copy of the what was put in the courts, so we won't have to guess what people said or guess what this one said. What you're reading from, is it a certified copy from the court?
Okay, well, let me say this. What you're stating presents two issues here. One, as far as subpoena, when you're trying to subpoena documents, you subpoena the court. They call it a subpoena ducis tecum. Okay, that means that you're subpoenaing the documents and not the person. One of the big tragedies in Dr.York case was that if there were any two people that should have been subpoenaed, along with the FBI agents, it should have been Cheryl Seals and Jacob York. Unfortunately, they were not subpoenaed, and the government was not going to bring in Jacob York to testify against his father, and that in itself raises questions. More than likely, the basis probably for the government not wanting to produce Jacob York and Cheryl Seals is because I believe or not that it really showed that Cheryl Seals was pretty much biased against the Wabian children as far as his investigation, which he claims started, around 1998. Yet still, there's no evidence that he had ever notified DFACS that poor children were on the land, being molested, until 4 years later, when DFACS all of a sudden pops up after Dr. York got arrested and started, doing a job in 2002 that they should have been doing in 1998. So that was the problem there. Also, you really want to find out what was the scope of Cheryl Seals and Jacob York's, Jacob York's relationship in this matter, and what had transpired. Unfortunately, they wasn't called on the witness stand, and I don't know, what Adrian had to contend with, what was what his rationale for not calling them. But more than likely, if I had to choose a basis, I don't think Adrian had the history, because Adrian was really involved in getting witnesses. This man had gotten over 42 witnesses, all right, and counting the witnesses that were really government witnesses, because an attorney can examine and cross-examine, his witnesses and the government witnesses as well throughout a trial process. So that was one issue there. But as far as your question about the documents and getting the certified documents, when I speak about this case, I always show the documents. I don't put myself in front of the evidence or in front of the documents. I put the facts and the documents in front of me. And then my only job is to try to interpret the best of my ability what the documents are saying. Now, keep in mind, a lot of these documents have been sealed by the court. So it's not like you can go into the court and say, yeah, I want this document and I want it certified. No, you have to first put in a motion to get the documents sealed. In order for you to get the documents unsealed, you have to show a grounds. You have to show a basis. You have to show a legal basis for that document.
All right.
Now,
so isn't there a statute of limitation on that though, on sealed documents?
well, there's a statute of limitation. Matter of fact, I don't know the particular statute of limitation in terms of citing you the statute, but I know the government, as far as the government's concerned, they have to release the documents inside of a certain amount of years. It's been almost 20 years now. So I believe that the documents are right to be released if the proper legal apparatus is put in place to request those documents, especially in light of the 65 sealed court orders, all right, that you want to see other documents in that case, so that you can make the case. And the only way that you can really do that is through a writ of habeas corpus at this time. Okay, so that means that the attorneys that you hire, they're gonna have to read the docket sheet. They're gonna have to get a history of the case. They're gonna have to start from the pre-trial up to the trial and post-trial. And that's another tragedy, that the attorneys that was doing the first writ of habeas corpus, that was Malik Zulu Shabazz, as well as Gregory Lattimore and another attorney named Green, I can't remember his first name, when they went forward with their writ of habeas corpus, they did not go far enough. They should have went to the pre-trial. There's no arguments based on the procedural damage, the jurisdictional damage that was started during the pre-trial in their writ of habeas corpus. They just went to the trial and tried to put all the blame on Attorney Patrick and put no blame and no injury as a result of the ineffective assistance of counsel on Ed Garland. And they argued, but they didn't argue sufficiently dealing with Jonathan Mark's situation, because nobody dealt with that August 13, 2004 transcript. The transcript of a trial is what you look at, because you can get so much out of that transcript in terms of the state of mind of the fighting that was going on within that trial. You can only get it through the transcript. That's why I don't care what they doing at a trial. What you tell me, all I want to see is the transcript, because the transcript will show me what I need to do. It'll show me what errors that was made by the judge. It will show you the disposition of all the actors in this trial scenario. So you want to do that, but there's been so many transcripts that's been sealed that you would have to put the legal forced into the court to have them unseal those transcripts.
All right. All right. We do got two hands up, but if, I would do want to hear, the other attorney's motion, etc.
I just wanted to know why did the documents get sealed in the first place? How was they able to seal the documents, and what was the purpose of them sealing the documents?
Well, I can't tell you the judge's state of mind as to why he sealed the documents. But a lot of times the court seals documents based on government's request for those documents to be sealed. It could be that the court felt that because there was a lot of interaction in terms of other people filing stuff into the court, the judge decided that sealing the documents, which is, you have a First Amendment right to see documents, but the court can decide against whether those documents can cause harm as far as what's going on in the court at that time, as far as witnesses, as far as other legal proceedings that should be sealed, such as court records, medical records, stuff like that. They can do that. But the thing here is that and within a reasonable time, those documents should be unsealed. But if you don't request them, then there's no urgency for the court to release it. There's no basis for them to release it. But they can't hold on to your right or documents that is going to be egregious to your right under the First Amendment to read those documents. First Amendment comes in not only what you hear, but what you say. So, that's a thing right there. So now, as far as in this case, I believe that the court had sealed a lot of documents because too many people within the community was putting in stuff, and I believe that the court was dealing with Nawabians who was extremely researching and putting stuff, together in order to unveil stuff that the court really wanted to hide. I believe they were afraid that the Nawabians were avid researchers, and they were afraid of the consequences of that. But the problem here is that at no time throughout that process of people putting in stuff did Ed Garland had ever put in or sent a letter of cease and desist to those who were meddling in the case, which as an attorney, he had the right to do. The question is, why would you allow people to come into and put in stuff, and you was the head and lead attorney in the case who was paid over $1.5 million to do the federal and state case? Why would you allow people to come and mess it up? Unless you wanted to be messed up. That's the only conclusion I can make.
That's right. We got the other question in.
Mm-hmm.
Sister Rochelle?
Yeah, I'm here. Can I ask you a question, sir?
Sure.
Okay. If you ask for a certified copy of the case file, no. Let me backtrack. I do apologize. You have the right to face your accuser, no matter what age, correct?
You have a right to face your accuser, but because in this case, the court can direct as to what point that right, all right, is available to you. When you're dealing with children, you have a statute called the Children Witness Protection Act. To that, as far as it's pursuant to Title 18, 3509D, where the government can request that certain witnesses not be available to you until the appropriate time for them to be available. That was done in Dr. York's case. As to, if you go back and you read the June 30th, 2003 transcript, you're going to find Ed Garland was trying to, matter of fact, not only the June 30th, 2003 transcript, but go back to the May the 13th, 2002 detention hearing for a bond transcript, where Ed Garland was trying to get the witnesses' names to be revealed. But the problem was, it wasn't the right time, according to statute, for the judge to reveal the names of those minor victims, or victims who claimed that they were sexually abused. So you had to until trial, and when the trial started, they had to put the names, as far as the letters, to represent the actual names of those who said that they were victims. So you had names like SW, PW, and stuff like that, and you only had 3 minor witnesses at the trial, according to the transcripts. So they have a lot of statutes, or quite a few statutes, that protects children from revealing themselves throughout the court process, until I always say that the law is the law until it is challenged. So once the law is challenged, then the courts, the Supreme Court will bring in a new president, or the circuit court may bring in a new president in terms of the law, the new law, and all that stuff can be overwritten. You have to have good attorneys, okay? I mean, case in point, you have to have strong and zealous representation. You look at the Bill Cosby case. The reason why Bill Cosby is walking out right now is the result of strong and zealous representation, okay? The reason why R. Kelly, and things are starting to turn around for him somewhat, is because of strong, zealous representation. In Kathy Johnson case and the other sisters, they had strong, zealous representation in Brian Steele. So this is what you gotta reach out for. You gotta reach out for those attorneys that don't mind challenging the systems and the powers that be. And you got attorneys out there like that, as well as you got bad attorneys. And you got more bad attorneys out there than good attorneys.
So my next question is, so when you get a certified copy of the whole case, right? Being though we're in a time zone that we are now, instead of it being HP or the letters, the alphabets, and all courts, everything that was sealed, because we get a certified copy, it has to open up, correct? Because people can go backdate stuff. People can go say, oh, I forgot about this, and then go put it in and then put it in backdate. We got something that it's 2023. They can go backdate it and say that it was in 2003. So we get a certified copy. That's what everything the judge see, all the lawyers see, and because those things we don't see as the outside people looking in.
Well, let me say this, sister. Every transcript that comes out of the court is certified by the transcriber of that transcript. Now, you can ask for a copy that is uncertified. You can ask it to be certified. But if you have the same information that you had on the uncertified, which is the same information that you have certified, okay, the only thing you did, that don't change the nature of the information. All you did was you showed the court that you have a certified original document. Original document is always preference above a copy. So in this case here, You know, if you got all the paperwork certified tomorrow, if it's saying the same thing it said when it was uncertified, then that doesn't change the makeup of, you know, what you're alleging or what you're trying to get across to the other side in terms of information. The question is it materially probative? If is it materially relative to the case?
Who I think it is, because the things that was locked away and thrown away with the key, and we can't look at it. I think those things should be looked at as well.
Okay, I
And
agree with you. Yeah, I agree with you. It should be looked at. But like I said, nothing's going to happen until you make a request for it to change, and that's the issue there. Okay, I want to start with Jonathan Mark's motion. It's a 5-page motion, 4-page motion, and if I'm permitted, I'd like to start on that, brother Ibrahim. Okay, this is the motion of Jonathan Marks that was filed into the court on May 26, 2004. Adrian's motion for new trial was filed on January 30th, 2004. Now we read Adrian's motion for new trial. Now we're going to read Jonathan Marks' motion for new trial based on new discovered evidence. He go on to say, upon the annexed affidavit of Habiba Washington, sworn to May 9, 2004, defendant Dr.York by the undersigned counsel respectfully moves this court for a new trial, pursuant to Federal Rule 33 of the Federal Rules of Criminal Procedure, on the ground of newly discovered evidence. Since the conclusion of the trial, the defendant has obtained evidence as set forth in Washington's affidavit that the prosecution witness, including Washington, Crystal Harding, Nicole Lopez, and Amara Noel, gave materially false testimony at the defendant's trial. The evidence was unavailable to the defendant until after he was sentenced. Had this evidence been available to the defendant at trial, it is highly probable that he would have been acquitted on all counts and that he would be acquitted upon a retrial. In support of the motion, defendant alleges the following. 1. On November 21st, 2003, a grand jury for the Middle District of Georgia returned a 13-count superseding indictment against the defendant. 2. On January 23rd, 2004, following a jury trial, the jury returned a verdict of guilty on counts 1 through 7 and 9 through 11 of the superseding indictment. Additionally, the jury found the defendant guilty of 13, a forfeiture count. The charges of conviction was conspiracy to commit racketeering in violation of Title 18 USC 1962D, count 1, racketeering in violation of 18 USC 1962C, count 2, conspiracy to transport minors in interstate commerce for unlawful sexual activity, conspiracy to travel in interstate commerce for the purpose of engaging in unlawful sexual activity with minors, and conspiracy to structure cash transactions to evade currency transaction reporting requirements, all in violation of 18 USC 371, count 3, transportation of a minor in interstate commerce with the intent to engage in unlawful sexual activity in violation of 18 USC section 2423A, count 4 through 6, travel in interstate commerce for the purpose of engaging in unlawful sexual acts in violation of 18 USC 2423B, count 7, and aiding and abetting the evasion of reporting requirements concerning the deposit of currency in amounts less than 10,000 in violation of 31 USC 5313A, count 9, structuring cash transactions to evade currency transaction reporting requirements in violation of 31 USC 5313A, counts 10 and 11, and forfeiture allegations with respect to RICO violations, count 12 and 13. 4. At trial, Habiba Washington testified that the defendant molested her when she was a minor, that she witnessed him molesting other children, that at defendant's request, she arranged the minors to travel in interstate commerce for the purpose of defendants having sex with them, and that defendant instructed her to structure cash deposits in order to evade reporting requirements concerning cash transactions over 10,000. Now, I can tell you by reading, and you have a 3,700 page transcript, and I have not even read all of those transcripts or those pages. As to the structuring charge, as to the Mann Act, the government did not prove its case beyond a reasonable doubt. Adrian was correct.
But,
That's why they had to get rid of those motions.
Exactly. It seems like that particular attorney's motion was trying to basically help the government dodge the bullet. I mean, the court dodged the bullet on their misconduct, on constitutional misconduct, etc. And he brought the subject matter back to basically particulars within the case.
Right.
You know, that's kind of what it looked like. He just came in there to save the court.
Yeah, and that's what he did. That's what he did. I mean, can you imagine being in a courtroom? You're defending the case, right? And your attorney, told you whatnot, hey man, and I know Attorney Patrick had to have shown Dr.York those motions, all right, that he had done, okay? Because those motions was in the hands of Dr.York's tribe. So they understood what was going on. And even those people who was actually involved in the legal case at that time, they understood that the judge had gotten rid of his motions, got rid of his errors as a result of Jonathan Moss' actions. The question that come to my mind is, why wasn't this attorney stopped? Right. If Abigail had already said that her affidavits was a lie, and Jonathan Moss had indicated that after he submitted his motion. When did he submit his motion? He submitted his motion on May the 26th, 2004. 4 months before the actual hearing, new trial hearing. When I approached him at that new trial hearing, I asked him before the sabotage, before he stabbed Dr. York in the back, I asked him, what are you going to do today? He said, we're going to make sure that the judge don't get rid of his motion. And that's exactly what was done. Right. We're going to deal with that, when we present what happened on August 13, 2004. So I'm not going to go into much of that right now, but we're going to deal with that issue head on. Okay. Let me finish this. At trial, Habiba Washington testified that the defendant molested her when she was a minor, that she witnessed him molesting children, and that at defendant's request, she arranged for minors to travel in interstate commerce for the purpose of defendants having sex with them, and that defendant instructed her to structure cash deposits in order to evade reporting requirements concerning cash transactions over $10,000. See, that's a problem. That was not said in the indictment. The indictment said less than 10,000. What that means is that they was trying to show that Dr. York, in the indictment to the grand jury, they were showing the grand jury the premise that Dr. York was money laundering.
Mm-hmm.
When you launder money, you have to have a specific initial amount, where it's 100,000, 2,000, 200,000, that you are breaking down in small increments to fall under the radar of the IRS cash transaction reporting detection. 10,000 is no crime to deposit $10,000 in your account. But if you deposit 10,000 and 1 penny, then you have to do a cash transaction report on the 1 penny.
But why is his motion saying something different about the 10,000, less than 10,000 in the transcript, but in his motion, it's more than 1,000. I mean 10,000.
Well, at the trial, they presented more than 10,000. In the indictment, they said it was less than 10,000, so that they can sell the jury, the grand jury, that Dr. York was money laundering. But they couldn't prove that he was money laundering, because if what you're doing, that you have to hide the money, if it's legal, then that's not money laundering. Money laundering is that you're trying to hide, as a result of illegal activity, monies that you made as a result of that legal activity. So what was the legal activity in the YB community? The legal activity, as far as the government concerned, was they were selling soap, they were selling toothpaste, they were selling books. That's not no illegal activity. They was running a business, and when you run a business, you only have, the only alternative you have to, as far as depositing in the bank, is to putting the money in under your mattress. Dr. York, as far as trial, they had his accountant on the stand. Dr. York had a history of paying his taxes without incident, without any problems, for over 30 years. If he was about a tax invasion, that's what money laundering, is, then he wouldn't wait until 1999 to start hiding the sum total of $44,289 from the IRS, when he had a history of filing taxes for millions of dollars. The money laundering thing was put together in order to bring RICO in over the Mann Act on a state crime that was already had exhausted the statute of limitations. The state of Georgia had ran out of the statute of limitations because the offense that they claimed started in 1993. They didn't take no action until 9 years later. Over 9 years later, because 1999, 1993, 1999 is 6 years on a 5-year statute of limitation. The state statute of limitation already ran out. That's why they brought the feds in to try to bring that structuring charge in, so that under RICO you had a 5-year statute of limitation. So they had to show the court that the sexual activity was ongoing even after the statute of limitation. That's what they put together. The problem I'm having with that is that the federal government, who claimed that they had Dr. York under surveillance for over a year, from 2001 up until the time he arrested him, had never brought into the court any evidence as to their surveillance in reference to, if Dr. York was having all this sex, they was able They could have shown, yeah, we were monitoring him, we were surveilling him, and we saw and we heard that he was bringing young children in, and they was having sex, and then the young children would come out. There was no surveillance evidence.
Right.
The only thing they showed Dr. York was doing, he was taking young girls to Walmart. He was taking young girls to restaurants and young boys. What? That's no crime. So they use that as an overt act charge.
So they're usually with their parents, so it's not. Yeah.
And Dr. York had a history. The man was a giving person who had a history of, buying clothes for his people, birthday celebrations. He would give them birthday presents. I mean, that was the history. So when you read the indictment as a Nawabian, you look at the indictment, you were saying, what organization is this? Because this is not our organization. This is not how we roll.
Yes.
So, it's this case really, Dr. York should have had a team of lawyers on this case at rival OJ.
Mm-hmm. And not a whole bunch of other things going on at the same time.
Yeah, and a lot of his attorneys should have been, attorneys coming in out of the state from without the state of Georgia, attorneys coming in from other states into this case. But, we can talk about that now, but the point of the matter is you have to talk about it because you don't want this to never happen to another group of Black folks or a Black organization that may similarly go through the same situation. And that's why putting information like this out is relevant. People need to see what really happened in that courtroom.
Absolutely.
They really need to see that.
We do appreciate you for, clearing things.
Yes, I'm trying to get through this real quick. In her affidavit, Washington, this is number 5. In her affidavit, Washington entirely recants her trial testimony. In substance, she states that Jacob York solicited her and others to falsely accuse Malachi York of sexual molestation. That thereafter, she conspired with Crystal Harding, Nicole Lopez, Amara Noel, Sakina Parham, Jamala Ellis, Alicia Chester, among others, to make false statements to the FBI and thereafter to testify falsely against Malachi York. 6. This startling evidence could not have been discovered until after the trial. Defendant's trial counsel, Adrian Patrick, sought diligently to obtain exculpatory evidence to present at trial. Indeed, he was successful in calling several alleged victims whom Washington and her co-conspirators claimed to have been having sex with the defendant when they were minors. Excuse me. Those alleged victims testified that the defendant had never molested them. Nevertheless, Habiba Washington and other prosecution witnesses testified that they have seen defendant having sex with those minors. His diligence notwithstanding, trial counsel was unable to discover the evidence presented in the Washington affidavit because Washington did not recant until after trial was concluded. At a hearing on defendant's motion, we will call Washington along with other witnesses, including Jamalia Ellis, who will testify as to the details of the conspiracy to cause defendant wrongful conviction. Wherefore, based upon the foregoing as well as the accompanying memorandum of law, defendant respectfully requests that the court grant an evidentiary hearing to determine whether or not a new trial should be granted, and following the hearing, that the court order a new trial. Now, let me ask you this question. You heard both Attorney Patrick for new trial. You also heard Jonathan Mark's motion for a new trial based on new discovered evidence. Did you hear in Jonathan Mark's motion for new trial, did you hear him say anything about supplementing Adrian Patrick's new trial motion?
No, of course not.
Well, that was what he portrayed to the court on Dr. York's April 22nd sentencing, that he wanted the Judge Raw to grant him time to get the transcripts so that he can supplement his new trial motion. He had already sent a objection letter to the court telling Judge Raw that he was going to supplement his objections with Adrian Patrick's objections. Why would Judge Raw allow Adrian Patrick's motion to be withdrawn when he knew that he had errors on that Adrian Patrick's motion? Why would he allow Jonathan Marks to do that? That's the question I want y'all to think about.
Let me tell you something. Not only will they persecute you, they'll lie on you. They'll fabricate lies. They'll imprison you and create cases around you. The same way they tried to defame the Honorable Elijah Muhammad, and then they tried to defame Malcolm X, and then they even tried to defame Dr. Martin Luther King by some secretary. That's what they'll do. They'll imprison you, and then they'll create lies to turn your own people against you. They'll persecute you after right the same thing. The same way I'm talking to you, they're going to come after me eventually. Believe it. They're going to say, that man is too dangerous. I don't like him. Let's make some lies up on him. Let's turn his people against him. Let's imprison him. And if we can, let's kill him, because his people won't help him anyway.
That's all I had. Appreciate that. Jabari, Jaheem, thank you again. Again, done the clapping. So, Neb, if you can take us out with the all affirmation prayer of the age.
Okay. Abdul ko ba zon tafila tat wadana bet ma hubadu aishu fi yana kalu. Anuki fi na aishu shukalu wa kula shukalu ni. Na ata kuna fi kalu. Anuki feragun shukalu wa kalu kalu feragun shuni. Anuki wahid ka kalu wa kalu kalu wahid man. Nuk aikilu anjihu kema feragun shukalu wa khub kama faidu. Nuk aikilu akoi nukudik nuka fizi fi kalu. Kema tawu kama kafazi kalu ni amidu fi kalu. Anuki kabaha wahud. Kalu kalu nanuki. Kalu Yaku Nukekibu, Kalu Babu Nukamilu. Again, all pairs think these indeed with who? Divine love and all. I am in the love of all, and all love is me. We are all in all. I am a part of all, and all is a part of me. I am one with all, and all is one with me. I could succeed as a part of all and fail as an individual. I can be all I wish in all, as long as my wish is to stay in all. I am never alone. All is I am. All can I can. All does I do.